Thank you so much, Todd. Hello, everybody, and welcome to AltaPro Live. My name is Jay Reeves, better known as the Risk Pro. This guy is the on-call practice management consultant for lawyers and firms insured through AltaPro. Maybe you've got a question. How do I grow my practice? What do I do with a stack of case files sitting here? Or how do I become a superhero on a stick, just like you, Risk Pro? Well, just go to our website, altaprorpg.com. That's RPG for Risk Purchasing Group, altaprorpg.com. Shoot us a question, and faster than you can say motion granted, the Risk Pro will zoom in and help you out. That's just one of the many benefits you get from being a part of the AltaPro family. Another benefit, free CLE webinars like this one today. If you've missed any of our prior webinars, you can go to our YouTube channel, the AltaPro YouTube channel. They're all available, absolutely free. You can watch them on demand. They're 1 hour long, and they include our wildly popular series on cybersecurity, a 4-part series on best practices for cybersecurity in your law firm. While you're there, of course, click on the subscribe button so you'll stay in the loop with future CLEs and offerings. And before I go any further, let me just say, on behalf of all of us here at AltaPro, thank you, our audience. You're the reason we're here. You're the reason these webinars have been successful. You've told us what you want us to talk about, and you show up. Today, we've got a couple of hundred lawyers, legal professionals, insurance agents, brokers from Texas, Michigan, Indiana, and even my friend Gary from North Carolina. I see you there, Gary. Thanks for showing up. Thank all of you for supporting us and being part of our family. Today's program is Legal Ethics in 3D. And we're going to talk about the dangers of dabbling, the importance of documentation, and how to deal with difficult clients. But wait, there's more. We came up with a 4th D. Don't do it. So that when you leave this webinar, you'll be able to see in 4D, because that's how we roll here at AltaPro. Our special guest, as Todd said, is James Bell. And we are delighted to have him. What Todd didn't tell you is that James has an interesting side hustle. James moonlights as the amateur life coach. And I think, Ben, I think we've got some video clips of the amateur life coach in action. And if we can roll a clip, let's take a look.
Sound. Yeah. Yeah.
Well, I don't think that's the coach.
Jay, there appears to be no sound.
There appears to be no sound, James. And there you are doing your thing.
Yeah.
Services provided to the needy. Some states are now requiring attorneys to keep track of the pro bono hours they perform annually. When attorneys take cases pro bono, they do it knowing that they're not going to get paid. They do it for the satisfaction of providing access to justice to those who desperately need it. But that's not what happened to you. You thought you were going to get paid and you got stiffed. The legal term for that is pro succo, which is Latin for it sucks to be a lawyer today. So let's practice a little more pro bono and a little less pro succo. How do we do that? Number 1, if you're charging a flat fee, get all your money up front. 2, if you're billing hourly, get a bigger retainer. 3, research the financial condition of your client. Because unfortunately, you can't retroactively change a pro succo hour into a pro bono hour, even if you're not suing your client out of the bono in your heart. Get it? Get it? Bono meaning good, like the goodness in your heart. What a room.
I love it. I love it. Sorry, we had a little technical difficulty. That video was on sort of becoming, doing involuntary, unintentional.
Alrighty, folks. So today, my producers have picked a video that they want to show me. I don't know.
There you go. That video was on becoming sort of an unintentional pro bono lawyer when you don't mean to. And what I love about James and why I'm thrilled that he's on our program is he's a serious attorney. He represents lawyers who are in big trouble, but he makes the points accessible and he makes them even fun because that's how we remember things. So James, I'm delighted to have you here. Thank you so much for being on our program.
No problem, Jay. Can you hear me?
What did you say?
Yeah.
Yes. So let's start with dabbling. What is dabbling? Why is it a big deal? Why are we talking about it?
Yeah, well, Jay, thank you very much. And the first thing I would say, and just making sure everybody could see me, I can't see myself here. So just, Jay, if you could just tell me if you can't see me or can't hear me. But that video is available on YouTube. ICLEF, Indiana Continuing Legal Education Forum, produced that video if you wanted to watch the beginning. So the jokes at the end sort of make sense, you may. But certainly dabbling is an area that lawyers get in trouble with. What is it? Jay, you taught me the word dabbling. I called it staying away from the gray, getting outside your lane. And I find that lawyers often get in trouble when they're in the gray area. They're out of their lane or they're dabbling. I think there are times when we as lawyers, we intentionally dabble. If there's a pandemic and all of a sudden the courts are closed and all of a sudden businesses are closed and all of a sudden you're looking at your phone and wondering whether it's even connected to the wall because it hasn't rang in a while. When somebody calls and you do family law and they have a personal injury case, all of a sudden you feel like, wow, maybe I need to take on that matter. So when times are slow, we dabble. Sometimes your client is a very good client and they tend to have a bunch of business problems, which is right up your alley. But when they have an employment issue or some other issue, you don't want to say no to your client. Sometimes we don't want to say no to our family member because we want to look very smart in front of our family. We want to be the hero for our family member. And then I also think we intentionally dabble when we see dollar signs. So if you go back to my personal injury or family lawyer says, sure, I could take on my family law clients personal injury case because I see dollar signs. And I think what happens, and Jay, when you were in practice, I'm sure you saw this, that it's hard to get to things if you don't know what you're doing. You tend to do the things that you're able to attack, that you're able to do, that you enjoy. And, we tend to gravitate to things we enjoy. Don't know how anybody enjoys family law, but that's a separate discussion. But it's a shame pile and you sit there and you don't get things done. So you're not communicating with your client, which we'll talk about today. You're not being diligent with your cases. And often that leads to dissatisfied clients, bad results, courts that are mad at us, and that leads to problems. I also think we sometimes unintentionally dabble. I used to do a lot of internal investigations for a healthcare company as part of my white collar practice when I was at a bigger firm. And there would be a bad event, sometimes even there's a death and I've represented people in murder cases before. I've represented people in neglect of a dependent case. I felt very comfortable doing an internal investigation to find out why a bad event or why someone died or whatever. Police sometimes were involved, federal agencies were involved. I felt very comfortable dealing with law enforcement, as comfortable as anyone can, dealing with law enforcement regulators, et cetera. But after I did the internal investigation, I'd write up my summary like the client asked. I would give it to the client. The client says, well, now should we fire this client or fire this employee? And I'm like, well, hell yeah. I guess I don't know. I'm not an employment lawyer. Do we need to report this to the Department of Health? Do we need to report this to Medicaid, Medicare, et cetera. And all of a sudden I find I was in my lane. I was not in a gray area. I was not dabbling, but now my client is forcing me to dabble. And one of the things that we often need to learn is, your client will respect you I think if you say, look, I don't know the answer for you right now on that one. I'm going to have to find you that answer. Certainly, we don't want to go see a doctor or see anybody that doesn't specialize in a particular area. I think we unintentionally dabble a little bit when we maybe, Jay, you did licensure work for professionals. If you're not keeping up with, you can do a medical license and get through the medical licensing board and maybe get your client on probation. Everybody's happy. Well, is he on the OIG exclusion list now? Did you look at that? Did you look at his hospital privileges, all the collateral consequences that come from that? And you're going to have an unhappy client who said, you never told me that was going to happen to me. You didn't set me up. You didn't allow me to prepare for that. And certainly you could even, like I do criminal work, and I find different courts sometimes do things differently. I mean, you could be, you could quickly get back in your lane or educate yourself. And certainly you can go a little bit outside your lane and learn and ask colleagues, et cetera. But that's how we get into dabbling. Jay, do you want me to get into the solutions to dabbling, or do we want to look at the poll question now?
Let's hold the solutions. So much good stuff you hit on there, James. A couple of things back a million years ago when I was doing some of this work, I called it the how hard can it be mentality. I'm a personal injury lawyer. I know how to represent injured people, so I can take a workers' comp case, can I? It involves medical bills. Well, probably not. And then with the family and friends, I call that the no good deed goes unpunished. We want to help our family. We want to help our friends. We want them to think well of us. So we end up doing something we probably aren't qualified or ready to do. Let's take a look at this question. As you know, the webinars that Alta Pro puts on are a group activity. It's not just talking heads, it's the audience too. So let's take a survey of our audience. Which of the following statements are true about dabbling or practicing out of your comfort zone or out of your primary area? One, more than 60% of all malpractice claims involve an area of law in which you work less than 20% of the time. Two, 46% of claims stem from a failure to understand the substantive law and specialized procedures in the area, which might be nuanced, sort of the personal injury versus workers' comp. Some very nuanced differences there. Three, attorneys who practice in a single area account for less than 7% of the claims, or D, all of the above. James, any guess on the correct answer there?
Well, we already have our results here. So I guess I would have guessed all of the above because, I'm seeing the answer. Is everybody else seeing the answer? Are they taking it? Did I just ruin it for everybody, Jay? I think I'm viewing Ben's screen here.
No, you're doing great. You're viewing it perfectly, and looks like almost 9 out of 10 got the right answer, which is good news for the underwriters at Alta Pro. I mean, I'm sure they're thrilled at that. Yeah.
Well, I'll just make a comment. I think as you look at this list, obviously there's 3 things at least to avoid here, or 2 things to avoid. You have to wonder about the 7%. Why is a person that sort of specializes, to the extent we can use that term, getting 7% of claims? My suspicion is some of it is going to be what we talk about later today, that you've taken on a client you probably shouldn't have taken on for some reason, even if it's in your area. Maybe you didn't supervise somebody. You got unlucky. There was a curveball in the case. But I will bet a lot of those are just bad clients who just can't deal with, the world as it is and the results that they got. And, we'll talk about the difficult client as one of the D's later, and maybe a little bit on how to avoid that person. So that's just a comment on these statistics that we got.
But that's a great comment. And remember, I used to tell folks I worked with, just because you can't take the case doesn't mean you can't help the client. You might can associate a lawyer who is qualified, maybe refer it to a lawyer who will reciprocate by sending you a case in your breadbasket. Not all of us, not all of us are like the Angels pitcher Ohtani, who can do it all. We do some things pretty well, and we do a lot of things not so well at all. So,
and I'll say one of the things that we don't do very well is enjoy slow times. When the phone doesn't ring, I tend to flip out. Well, so far in 20 something years, that hasn't continued indefinitely. And I find myself, why was I ever worried, swamped? We need to enjoy, when you get a lull, maybe enjoy it. That's a time to go hang out with your family, get some exercise, clean your office, get organized, do all the things that you say you're going to do that you never do. But you can still make money off of referrals, even if they're not in your area. We'll get to documentation, but certainly we want to, at least in Indiana and the model rules, we want to follow 1.5E when we're sharing a fee. Your firm should have in place somebody that's saying, no, you're not taking that case, but this guy can, and your firm ought to have a policy about origination so you can make a little bit of money off of these things that come in. And of course, Nancy Reagan told us to just say no, and we just need to be honest with ourselves sometimes and just be able to say, this is out of my league, just say no. So
great. And for our audience, we can continue the conversation. You can continue it with James. You can continue it with me and AltaPro after the program. We could spend a whole program talking about comfort zones and the risks of stepping out and solutions. But let's move to the second D, which I believe is documentation. From carbon copies to the cloud. And I am not too proud to say that when I started practicing law, we used carbon copies, James. A young man like yourself, you may have trouble believing that, but we use carbon copies.
Yes, people are astounded that I actually had pink slips and that we would dictate memos to each other. So yes, I could put myself there a little bit. We didn't have email, when I first started. So
is documentation a big deal? Everything's in the cloud now. We don't do paper as much as we used to.
Yeah, to me, documentation doesn't mean it has to be on paper or in carbon copies. If it just because you're paperless, quote unquote, or in the cloud. I've never managed to truly be paperless, although I'm trying and I understand the value in that. You still need to be communicating. You still need to be setting expectations. It is. We are going to again talk about the difficult client as one of our Ds. Documentation D is a defense D to the difficult client, another D. I mean, that is, the jerk client it's never going to be that person's fault that they're in the problem, is going to say, you never told me that, you never warned me this would happen, this was all your idea. And if you are constantly communicating with, here's what I told you, here are the facts that I shared with you, here's what we've decided, or you decided as a group, here was my advice, you chose to do this. If that's all documented, that you can sort of throw that back into that difficult client's face, so that can stop them from going down a road where they think they can get away with blaming you. Of course, if they do blame you and you get a grievance or a malpractice suit, you will have a documentation. If somebody else needs to get up to speed on the case, and there is that paper trail, either a log, which often our time entries are good logs to follow. But even if you're billing a flat fee or a contingent fee, you should keep a log of what you're doing. You can piece back together what has happened in the case. I have a list of things, Jay, that I think we should document. And then I have a very tiny list of things that we should not document. Is that a good time to maybe give that list?
Definitely a good time. Let's ask a audience question, and while they're answering the question, you give us the list. Ben?
Okay, sounds good.
So documenting your case file is important only if you're charging for your service. Should begin with your first contact with the client. It's unnecessary if your office is paperless, will be of little help if you're defending a malpractice claim. Which is the correct answer? So James, tell us what should be documented and what we might not want to document.
All fee agreements, I think, should be documented. If it's contingency fee, you have to. Okay, that's 1.5C. I assume that's uniform across most states. I think it's more important, if and a flat fee. When do you earn the fee? How far are you going to take that client? There's a lot. Hey, I'm going to take your DUI case. And that's all you put in there. You haven't really earned the full fee until that case is absolutely over. If you say, I'm taking on your divorce case for a flat fee, when do those cases ever end? There's post-dissolution. I mean, you'd have an appeal, et cetera, et cetera. So it's important. I think all fee agreements have to be in writing. Document what you are taking on in your engagement letter, your fee letter, and document, I think, what you are not taking on. I will represent you in X. We do not represent you in anything else, because there have been malpractice claims where somebody said, I'm going to represent your business, or I'm going to give you business advice, or I'm going to give you, et cetera. And somebody comes back when there's a bad result and say, you were supposed to handle this. Well, you and I know, and the lawyer says, you and I know I wasn't ever handling that, let's say, tax issue. They looked at the scope of engagement, and it's really broad. And, some smart plaintiff's lawyer could try to make a case that you promised to take on every problem for that business because your scope of engagement was too long. One thing that I don't do enough of is a declination letter or a quick declination email. I am not taking this on. There are people that, with personal injury lawyers, there's lots of cases that you can go find where somebody got injured, went to a plaintiff's lawyer said, you don't have a case. And, that person, later was still injured. The statute had been blown, and there's only one person to sue at that point. And the plaintiff's lawyer chooses to sue the guy and say, hey, prove to me you weren't working on this case. Obviously, waivers, consent, screens, conflict, the fact that you did a conflict check, that needs to be documented. Documentation can help you control the difficult client. They can outline the process for them, give them expectations, lower their anxiety. They can keep good clients happy. Clients really don't want the smartest lawyer in the room. They want someone, I think, first, that is invested in their problems. So if you're documenting, here's what just happened, getting to them quickly, giving them bad news quickly, they believe that you care about their problem. That is going to keep a good client happy, even when things don't go well. Communicate when you're done. I think we've all done the blue ribbon sort of letter just to say, hey, here's what you could document. Document settlement authority before you make a settlement offer, just to make sure that you're not getting out ahead of your skis. There have been problems with that. And Jay, the one thing I could think of that I'm sure there's other things not to document, but the two things I could think about that you really don't want to document, because this makes a problem a bigger problem. And that is, you don't want to vent about a client in writing, even within your firm. I think there's this idea, everything's confidential, everything's privileged. I would suggest to never insult your client, blah, blah, blah. But if you do it orally. Just walk down the hall. And there have been a lot of cases. I went into another seminar, somebody from, was talking about risk management. And they said, with COVID, with the pandemic, with people not in the same office, when they get a grievance, they get, a demand letter. When things go badly, they flip out, and they flip out on email instead of going down the hall to talk to somebody. And our emails, our communications with our fellow lawyers in an office are not privileged communications, even if that's to a lawyer. Now, if it's your designated general counsel, there's some exceptions, but those communications are not going to generally be considered privileged. Oh, damn it, I screwed up. That may be exhibit A for a plaintiff lawyer in your malpractice case. So I would not document your anxieties and your venting and your frustrations. And I'm sure there are other things not to document as well, but those are the things that came to mind immediately. Jay?
Thank you, James. What great advice. I think, that first contact or the engagement and what I would call the disengagement, the cutting loose, those are so important because that brackets your representation. That's a clear, here's when I started, here's when I ended, for statute of limitations, other purposes. Very, very important. And also documentation doesn't have to be paper, digital documentation just as important. Documentation can mean what you send to your clients. James used the phrase, it can keep your clients happy. Of course it can. Rarely do clients complain that their lawyer is giving them too much information, or they're just sending me too much stuff. Just stop with the law stuff. I don't want to know. Some do, some might want to, but most like being informed. And if you can show that I kept my client in the loop, we were both engaged in this case, that's going to really help you out, and it'll keep your client happy. And one final comment, for Alta Pro insureds, you get a discount on Clio. This is not a paid announcement, but you get a discount on Clio practice management software products. That's a digital solution for documenting and storing, etc. So if you're interested in looking at a cloud solution, you can get a little discount if you're with Alta Pro. James, let's take a look. It looks like we have an awesome audience today, because 99% says documentation should begin with the first contact, which I think is the right answer.
I would say so too. It's, it's unnecessary if your law office is paperless. Nobody said that. I mean, everybody understands that just because there's no paper doesn't mean you don't document. I could see if there was one person that said to charge you for the fee for the service, probably if you just got confused over that rule about contingency fee or things like that nature. And again, we talked about, when it's not a help for documenting, but when you're documenting your file, that is part of the, it's something, sometimes it's an afterthought. Sometimes it's, oh God, I have to do that. But, you are documenting the file for a reason, sending CYA emails to your client, with settlement authority for a reason. And, more likely than not, you've done the right thing in your case, no matter what the result was. And more likely than not, the more documentation you have, the more helpful it's going to be. The things that I can think aren't helpful in those cases, again, are those venting frustration emails.
And James, so, I think your frustration. Don't vent. Don't put this in writing. That's so important. In fact, my first law boss used to say, Reeves, don't put anything in writing that you don't want on the front page of the paper tomorrow morning. Good advice. Maybe a little bombastic, but the point was well taken. And I would even go further and say sometimes you don't even need to be thinking or saying some of those things. To your colleagues. If you're venting, maybe you need to go meditate on that and think about, well, maybe you're the problem if you find yourself always frustrated or having to vent about this awful client. But absolutely, some things do not belong in writing, and maybe don't even belong in your head thinking. So let's get to a better place there. Okay.
Are we listening? We're still listening. So.
The audience has to say they're still there. They're still cognizant. They're still alive and listening. So let's move to the next topic, the third D, dealing with difficult clients. And my gosh, James, I'll bet you could spend 2 days talking with this. And although perhaps some of our audience have never had a difficult client. Maybe they've never seen one of these things, but I'll bet most have.
Yes, there are some lawyers that live the blessed lifestyle of one client for life, and it's somebody that they get along with. But yes, I represent lawyers and judges for a living, so I've never had a difficult client. Ha ha ha. The thing about difficult clients are, for most, I would assume almost all of us are in private practice of some sort, or you wouldn't have, need for Alta Pro insurance and risk management. But, you have the ability with that law license to take on any case you want and decline any case you don't want. And one of my mentors in one of my law jobs, Jay, like you just got me thinking about the first guy I worked for. He said he quoted F. Lee Bailey in doing this, but there were 3 reasons to take on the case. And that was, you like the client, you like the cause. And if you didn't like the client or you didn't like the cause, it had to be about the money. And I've now done this for 2 years. And I'd like to modify that you take on a case because you like the client, you like the cause. And by the way, you ought to get paid just like you get paid in every other case. That you're not going to take on somebody that you think is a jerk, that's impossible to work with, simply because you will get a good fee at the end of it. It's almost never worth it. I always think about, people ask, non-lawyers ask, what was the greatest ruling of all time? And they're expecting me to say Brown v. Board of Education, Miranda versus Arizona, Marbury versus Bassett. I always think of the 2 or 3 motions to withdraw that I filed, and those rulings that I got when they were finally granted. It was hallelujah. I never felt so much better. And I always say, I'm going to avoid this person. I mean, this is a great way. It's a challenging way to make a living. You're never bored being a lawyer, but you can take your work home. It can affect your personal life. We'll talk about taking care of yourself later. But you don't have to make your family's life miserable because you've taken on a jerk client. Keep in mind, there are clients that you will do a great job for, and they will think you didn't do enough. And then there are people that you try your hardest for, you get them an okay result, or maybe it doesn't work out at all, and they're very grateful for your effort. And that just, I think that's a reflection on who those clients are more than on your abilities. So, the biggest solution is to be able to avoid them. There are a lot of fraudsters out there. Some people charged with fraud, Jay. I know this is going to be crazy. They lie to the lawyer. They lead them down wrong paths. If you could try to avoid those people, and if you don't avoid them, try to get out as much as possible. At the end, just keep in mind, when you file your appearance for a client, you are not married to them. This is that you didn't swear before God that you'll have in the hold, et cetera, et cetera. Feel free to break up with these people and feel free to say to them, it's not me, it's you. That you need to break up. If you're stuck with these clients, or you're not quite to the point where you want to get a client divorce, being able to control them and work with them through a difficult time, I think there's an art to it. It helps to have gray hair. I have grayer hair than I did 10 years ago. I found that, a lot of my clients now are younger than me, and that just helps in and of itself. And then you've had more experience, but you need to train them. I think hourly billing, maybe people don't like to hear that. I think that controls clients. They know, and you need to train them that they're going to pay you. I get retainers, even on cases I'm sure the client's going to pay. I just want to send the message at the beginning that this is for money. And so the moment they talk to me, they know they've sent me a check, they've sent me some sort of retainer, they know they're paying for this. And that means every 30 days they're expecting a bill, and their expectations are going to be shaped by that bill coming. So bill early, bill often. Maybe that's an ugly thing to say, but I do think you have more control over clients that way. Don't enable your clients. Don't make them a bigger jerk than they already are by entertaining or pursuing every idea they have. I think you should listen to every idea they have. But when you envision, the kind of lawyer that you want to be, or that you would want to have, do you really want the bulldog or the gunslinger? Or would you rather have somebody like Yoda from Star Wars, somebody wise, somebody that you could feel comfortable saying something to, and they would think and give you a reasoned answer. There's a line somewhere along the way, having represented lawyers and judges who have problems because they step over certain borders and boundaries with clients. But it helps to sympathize with clients, maybe not empathize. Atticus Finch always talks about walking around in somebody else's skin. And of course, there's a lot of symbolism there because of racial issues in Alabama now, but certainly back then. And I know it was only a book, but I do think it's dangerous to walk in your client's shoes or your client's skin. You still need to be the lawyer. You need to be neutral, but you shouldn't be enabling them, etc. Bring in help. I think it's another way, when they get to be jerky. you know, with their consent, of course, you know, maybe you need to recommend them to a therapist. Maybe you need to bring in another lawyer to help. You know, some instances, depending on the circumstance, maybe a family member, somebody that they listen to more. Of course, you'd have to have the right consents and you'd want to document that you got those. But sometimes you're going to need help dealing with people. So if you can avoid them, do avoid them. If you're stuck and your life's miserable, life's too short, get out of the case, and then don't feed the beast if you're stuck with a client. You know, control them and then allow them and be the best lawyer you can be for them by listening to them, but not entertaining every thought. Jay?
Thank you, James. One of the mistakes, the many mistakes I made as a younger lawyer, not that I don't make mistakes now, was I used to think I could turn the client around, a client who had unreasonable expectations, who was just difficult to work with. I used to think I could change them or they would change. Rarely did that happen. That was I was too enamored of my own powers of persuasion. So I think identifying high-risk clients up front and avoiding them is the best way to deal with trouble later. We often make the mistake out of the goodness of our heart, but not the acuity of our minds. So this question that we're asking the audience gets right to it. Which of the following are some red flags? They've had multiple attorneys in the case before calling you. I call this the serial client. They say it's not about the money. Money's no object. I just want to make the other side as miserable as possible for as long as possible. They're looking for the cheapest lawyer available, and guess what? You're it. Or they don't pay your retainer. And guess what? Charging a retainer is a good way to screen clients. If they don't pay it, that's probably a tip-off, not the person I want to get into business with here. And then they say something else. My case is a slam dunk because I've done all the research, all of the above. Again, 99%, these questions are either too easy or our audience is on fire here.
And they're also very good looking. So, all right. Not that I would ever suck up to an audience, but.
Back when I was a risk manager doing audits, I visited a law firm and they had a fire a client day. I think it was once a month. It might have been once a week for all I know. But that sounds pretty harsh and rude. But this firm would gather everyone together, you know, the front desk people, the legal assistants, and they would talk about, you know, what is sapping our energy? What cases and clients are grinding this firm to a halt? And they'd take a vote and they would let one client go. They would fire one client. It did wonders for staff morale. James and I both would caution you to read the rules of professional conduct. 1.16 tells you when you can withdraw. Sometimes you have to have court permission. But you know what? That's a wonderful advice. Sometimes you have to let go. And guess what? You're probably doing the client a favor as well as you a favor. You're certainly doing your staff a favor. So any other thoughts on difficult clients, James?
Yeah, I just said that question sort of highlighted the people to look out for. You know, the person with the multiple attorneys is probably someone that just can't get along with any attorney. The person who's saying it's not about the money, they just want to inflict pain. They don't want a lawyer. They want some way to vent their anger at somebody. The cheapest lawyer in town says, look, they're not going to, they don't want to pay for a lawyer. They are not going to value your services. And same with the slam dunk client. The one client that's not identified here that I used to always get as a criminal defense lawyer working at a big firm with some very politically connected lawyers was, they would go through the politically connected attorney who, didn't do criminal defense and, had some connections in government, things like that. And I noticed that when I started talking about interviewing witnesses, researching the law, deposing people, filing motions, that they seemed to be bewildered, that they thought they had hired a fixer. And, they didn't actually want a lawyer, they wanted a fixer, and I'm not a fixer. And, those were clients that could have never been satisfied. And they were people that really just wanted a lawyer there just say they had a lawyer, I guess. They wanted to be the lawyer themselves, and wanted to go out and sort of fix things in the background, and thought maybe I could do that as well. And so anybody who wants a fixer and not a lawyer, I'd say that's another person to avoid. Or who wants to be the lawyer themselves, talk to the witnesses themselves, bring you all the information. I think we could maybe avoid those people, because it's going to lead to bigger problems than just ethics and malpractice.
Great stuff. Great stuff. A final bit of wisdom I got from my first law boss. I'm going to keep dragging my first law boss into this discussion. This was back when I did have hair, and it was not gray. He used to say, Reeves, if you have one difficult client, that's just the name of the game. That's the nature of the business. If you've got two, that's unusual. That's a problem. If you've got three or more, you might want to go look in the mirror, because you're either taking the wrong people or the problem is me. So good advice. If you find yourself in a pattern of difficult, frustrating, no-win, impossible cases, maybe you need to examine what you're doing. How are you screening clients? How are you advertising for clients? Maybe the problem is not so much the client as the systems and the procedures you're using. So let's move on to the next topic here. Leave our clients behind and move to the fourth D. The fourth D, there we go. Just don't do it. My gosh, we could spend all day talking about things not to do. James?
Yeah, well, there's a whole a group of rules. The rules of professional conduct tell us what not to do. As I tell that fixer story, I start thinking about Michael Cohen and some other lawyers that got so invested in their client and who they were to themselves was a reflection of who they represented, and they just went off on these bad paths. And so when I taught professional responsibility at IU McKinney, I would always start certain discussions with my favorite TV show, Breaking Bad. And for those of you who have never watched Breaking Bad, Walter White is a nerd chemistry teacher who is dying of cancer and wants to leave money for his family. So he finds an old student named Jesse Pinkman, and Jesse Pinkman is a drug dealer, street level drug dealer. And so Walt makes the meth. It's the greatest meth on earth. And then Jesse's the one that gets it to customers and brings in the money. Well, they start to have some success and they start to feel the heat from law enforcement. So Jesse brings Walt to see Better Call Saul and Saul Goodman. And they're outside his office, and it's an office for sleaze. It's a sleaze bag office, sleazy operation. And Walter, the nerd, turns to Jesse, the drug dealer, and says, surely we could do better than this. He said, Mr. White, we don't want a criminal lawyer. We want a criminal lawyer. And so he wanted a lawyer that could fix things. And that's what Saul Goodman did. He didn't give legal advice. He gave illegal advice. He gave advice on how to hide bodies, how to get away with things, how to launder money, et cetera, et cetera. And certainly nobody on this seminar is going to think to do those sort of things. But there are cases in Indiana where, a lawyer, through no fault of his own, winds up possessing child pornography, or goes to do an employment case. And when he's collecting the documents, turns out that a teacher is involved with a student and there's photographs. And all of a sudden, this lawyer is possessing, something that would be a criminal act. There is a big debate in Indiana right now over when we have a duty to report child abuse as lawyers, and when we learn of that information through privileged means. So, always be aware of where the line is, and not certainly, again, Saul Goodman is in a different universe, and nobody on this seminar would be Saul Goodman, but know that your clients do give things to you, do put you in spots where you're possessing something you don't want to possess. They've mailed you something you don't want to possess. There are lots of systems now on the internet where somebody will, you foreclose. I need a foreclosure attorney. Somebody in California that's not even a lawyer will get that referral and send it to an Indiana lawyer to just do some paperwork. That's the unauthorized practice of law. Avoid those marketing schemes. Obviously, you want to avoid ex parte proceedings. keep in mind, a lot of these Zoom calls are recorded. Certainly you don't want to say anything you would regret, but recording, just know that a lot of things are recorded right now. I find in my clients, even when they make a mistake, if they are civil lawyers, have a reputation for being good people, easy to work with, that sometimes they get some slack that some other lawyers don't get. So I would say don't be a jerk, as some of the things to quote, don't do. Don't ignore the voice inside your head. Avoid or don't, if you see a suspicious link, don't click on it. Don't let your trust account be used by somebody who says, hey, look, you've never met me before, but I have this business deal worked out and both sides are on board and I just need you to paper it up and we'll put $400,000 in your trust account. And, if you could just transfer this money through a wire, blah, blah, blah. There's lots of lawyers who've been scammed by that and have used their trust account to be used, as part of a scam to sort of get people money that they aren't entitled to. We talked about it a little bit, but don't neglect self-care. Take care of yourself. Don't go without insurance. That's a very important thing to just sleep at night and to enjoy yourself. So I see the poll questions up there, Jay. So I'll let you sort of introduce that to the audience.
Yeah, the poll question sort of gets at the literal don't under the model rules 8.4. Here are things that you should not do, or if you do them, you'll have to pick up the phone and retain James Bell to represent you. And again, 99% got that it's okay to laugh at lawyer jokes. You don't need to call James. You can call me and share the joke with me. That's fine. But these other things, stay away from that. Lots of things to not do. And James, I thought it was interesting when you're talking about don't become too attached to your clients. Don't let the client drag you down. That got me thinking. That's sort of what I was trying to say when I thought I could turn the client around.
Yeah,
I'll get them to be reasonable or to see the light. But what was more likely to happen is I was going to go right down to the bottom with them. So great advice, great advice. Also, I want to acknowledge a couple of great comments. This is back to the client relations. We had one suggestion or one comment. I have a provision in my client agreement that I can fire the client, discharge the client, terminate. That sounds a little kinder. For failing to pay, failing to cooperate, failing to return calls and emails. Pretty good advice. Here are some conditions for us doing this dance together. And if the conditions aren't met, there will be consequences. Another good comment, I have what I call the lunch rule. If I can't envision having lunch with them on the day of their deposition, then I won't take the case. I have to at least be able to tolerate the person enough to spend non-mandatory time with them. I think that point is well taken because the rules don't require us to like our clients. I don't think they require us to like our clients, but it sure makes our life easier if we get along with our clients, if we represent people that we sort of understand, we believe in the cause, as you say. So those are some pretty good observations from people who are out there doing it in the trenches, James.
Yeah, the lunch rule is hard for some criminal lawyers with their incarcerated clients, but I do think certainly if you have the luxury of liking your clients or at least seeing the redeemable qualities in your clients. And, a lot of that's luck. You sort of find out whether you like your client, maybe not in the first or second meeting, but in the middle of the case as they deal with adversity. It certainly makes the practice of law way more enjoyable, way more rewarding. And, again, I think a lot of what we're talking about is, you can keep your client happy and they will like you and you will like them if you're not dabbling. If you're controlling them with documentation, you're avoiding taking on the difficult clients. And of course, knowing where all the lines are. And if sometimes you don't know where the lines are because you're dabbling, that lawyer that I talked about. He was an employment lawyer, went to fire a teacher who had had an inappropriate relationship. He ends up taking, I'd say, unintentionally dabbling or getting out of his lane unintentionally, because he did what an employment lawyer does. He went and gathered all the documents. Well, some of the documents were texts that had stuff on it that, you know, nobody's supposed to have except law enforcement. So all these things I think will help, not just avoiding problems, but hopefully help everybody enjoy the practice of law more, because it is hard, it is stressful. And, you know, when you have a client you can believe in and that you would have lunch with them. And I'm going to start using that lunch rule to the extent I can as a criminal lawyer. You know, you would certainly be happier and prouder of what you do, I think, than if you're all constantly beating your head against the wall because you're running into a client that just is hard to reach, that even young Jay Reeves couldn't reach, you know. So anyway, so those
James,
are some concluding comments on don't.
Great comments. We're almost out of time, but I know I found it interesting as you and I were preparing for this program that we're sort of doing the same. We've done some of the same things in the law, and both of us have arrived at a point where we both understand, I think, the importance of self-care and the importance of attorney wellness. And really, that's at the root of a lot of these problems, you know, with dabbling, difficult clients, doing things you know you shouldn't. It's the attorney just isn't taking care of herself or himself, or making enough time and space to take care of themselves. Your thoughts on that?
I mean, I think that's right. I think it's, you know, you have to have balance. You know, these billable hour requirements, depending on what sort of practice you're in, can mean that you are working every waking hour, really, and then you're not exercising, you're not hanging out with your spouse, you're not hanging out with family, you're not doing the things that sort of help you recover from the day, you're not taking weekends off. And I think if you're going to deal with some of these problems, you know, you got to have your own sort of stuff in check, but you got to come ready, right? I mean, if you're going to be blocking and tackling for them, you know, sort of be the thing that stands between them and the government, you got to be ready, rested, and at your best. And if you're not taking care of yourself or noticing the problems that develop, you're going to have issues. And certainly we have a great lawyers assistance program here. It is not disciplinary stuff. I've referred so many people there. I think they've saved some of my clients' lives, literally. And everybody should be taking advantage of those things and listening to your friends when they approach you and say, look, you might not want to hear this, but so anyway, Jay.
Great. And here's a plug for our December webinar coming up in December. We present our annual year-end wellness webinar, and our guest is Michael Kahn. He's an attorney, and he's also a licensed counselor and therapist. He works with attorneys and other professionals. He's been a guest before. He's a terrific speaker. So be looking out for that one. Wellness free CLE webinar coming up in December. Well, I think we're about out of time. James, thank you so much. Thanks for coming. Thanks for your video, and thanks for your expertise.
I really appreciate your having me. Thank you.